what do you think are the remaining, obviously we've got the safe space, not safe spaces, the um, uh, sensitive places exceptions, which I am surprised that New York just went whole hog on it right away. DC got into the same fight over concealed carry a couple years ago, and then didn't want to take this to the Supreme Court, so they gave up. And I thought that everyone was going to start modeling their laws after DC, because that hasn't been successfully challenged since they went to shall issue, and they have a lot of sensitive places restrictions.
Yeah, I think there was recently a challenge to the Metro.
Yes, Heller himself is back and challenging that again, and that is probably one of the more controversial parts of DC's sensitive places rules, because it basically cuts off concealed carry for a lot of people who live in DC, just like New York's does. But regardless, what are the other areas that you see as remaining to, as being real open questions? I know there's a lot of critique, for instance, of, the common use standard, this idea that guns that are in common use for lawful purposes are presumptively protected by the Second Amendment. This is something that will likely be litigated thoroughly in the assault weapons ban cases that are coming through the federal courts, including the one that the Supreme Court just sent back down to the Fourth Circuit. But what are some of the other areas where there's just going to need to do a lot more litigation on?
Yeah, it's a good question, and you mentioned the court, granting cert, vacating, and remanding 4 cases that it had been holding while it decided Bruen. And I think, one of those cases, the Hawaii case, was very, very similar to Bruen. Hawaii had a restrictive provision in its permit scheme that I think went even a little further in requiring people to show some exceptional need. But the other 3 cases are not concealed carry cases. I think there's an assault weapons ban case, a magazine case. And so, there I think was some thought that maybe the court would actually grant cert and take one of those cases. They haven't. They've sent them back. And I think we'll sort of wait to see what happens there. Just on the assault weapons point, there was I think late last week, a federal judge in Colorado issued a temporary restraining order of Superior, Colorado's assault weapons ban. And it's a short opinion. I think there's a page or 2 of analysis that basically cites some federal appellate dissents and says these statistics show that semi-automatic weapons, are popular or are commonly owned for self-defense. That means that they are protected by the Second Amendment. And, the judge found that there was a likelihood of succeeding on the Second Amendment challenge there and enjoined the law. Important, I think, to note there that's an emergency application, right? That's not sort of a full determination of how that will go. And it doesn't appear that there was any historical discussion, right? Of is this actually consistent with history? Right. Which would of course, be the next step under Bruen.
Another important point right there is that he was an Obama appointee, which is interesting as well. Not that every judge is, you can predict exactly how they're going to rule based on who appointed them, but it is, it's an indicator, I would think.
Sure. And it'll be interesting to see what happens once there's sort of a more fulsome opportunity for the parties to actually to brief that case. We've seen some courts actually applying Bruen. It's been kind of I don't think like the avalanche that you would expect, just because especially at the federal level, these things can move relatively slowly. But there's been a lot of litigation, as there was in the intervening period between Heller, McDonald, and Bruen, about these group prohibitors, right? So you have criminal defendants saying, I'm challenging the felon gun ban, right? And those haven't gone very far, right? Even after Bruen, the courts are still saying that those are fine. And I think the opinion supports that for the most part, at least as to most of those prohibitors. So I think that's an area where we'll continue to see those cases come up pretty frequently. You mentioned earlier this thing that New York is doing, which is, I think it is, novel in that I don't think other states have done it yet, although it may be under discussion in some blue states, which is to flip the private property default, right? To say that that the default used to be that you could, if you had a permit, you could carry your gun unless onto private property, unless the business or something like that, unless the owner posted a sign saying guns are not allowed. Now it's the opposite. The assumption is that you can't carry there unless explicitly allowed, and that's a tricky one. I mean, there have been challenges already to that, but it's not really clear what the hook is, right? I mean, because there are also cases out there. There's I think an 11th Circuit case that it holds, and I think it's pretty clear. I mean, this isn't exactly what New York's law does, right? But it's clear that you have the right to keep guns off your property if you say so, right? That's always been true, right? You have a property right to say you can't carry guns in my business if I tell you not to.
Sure.
So
although there have been some exceptions with like employees and cars and
parking
lots
lot,
and stuff.
Sure,
but yeah,
sure.
But generally, yeah.
So I think if we see other states doing that, I think it'll be fascinating to see what types of challenges there are. I'm sure there will be quite a few.